Hi everyone. I am reviewing Hardwick versus the American Boy Choir School, 368 New Jersey Super 7177 845 A.2D 619 Appeal Division 2004. Some facts about this case is that the American Boy Choir School was an all-male boarding school in Princeton, New Jersey that served students from 5th grade to 8th grade. Most of those students lived on campus both during the week and on the weekends and were supervised by faculty and staff. This school was known for musical education, but specifically for the boys' choir. They were very famous. They traveled all over the country and internationally, and they also brought in a lot of revenue for the school. The person in charge of the choir and one of the administrators of the school was the music director, who was hired in 1986, and his name is Don Hanson. The same year, John enrolled in the school, and he claimed that Don Hanson and other staff members and Hanson's personal friends repeatedly sexually assaulted him at the school over a 2-year period. Additionally, he claims that when Hardwick finally unenrolled in the school, Hanson still pursued him over that summer and continued to sexually assault him both outside of the school and within the school. So the issues here, the plaintiffs, which are John Hardwick and another former student, Douglas Palmetier, are suing the school, Don Hanson, and various other staff members accused of sexually assaulting them, stating it's violating the New Jersey Child Sexual Abuse Act. And they felt the school was grossly negligent in protecting the students from sexual abuse and were aware the abuse was taking place. So the court's initial decision was to dismiss the case for a few reasons. The first is that the New Jersey Child Sexual Abuse Act, or the CSAA, states any person who knowingly permitted the sexual abuse would be civilly liable. And the court determined that the school was not a person that the act could apply to. Another reason the courts dismissed the case was the Charitable Immunity Act. So this act protects charitable organizations from civil liability, especially for negligence. And lastly, the court also dismissed Hardwick's claim against the school for the abuse he suffered from Hanson even after he had unenrolled from the school, stating that the perpetrator was still employed and technically protected under the Charitable Immunity Act. After this ruling, the plaintiffs then appealed the lower court's decision, and the case was moved to the New Jersey Supreme Court. There, the judge ruled in favor of Hardwick, stating the school was operating in loco parentis and was considered a household. The judge determined that the word person in CSSA did not exclude the school from liability because of their in loco parentis status. The judge also determined that the Charitable Immunity Act only protected institutions from negligent torts, and that this case was an instance of willful, wanton, and grossly negligent conduct, not just a negligent tort. Therefore, the Charitable Immunity Act also did not apply here. So, some opinions and the application to today in education. The initial ruling of the court was extremely disturbing. The CSSA and Charitable Immunity Act are designed to protect individuals, but in this case, they were almost being used to provide reasons as to why the school and defendants were not at fault. But after the Supreme Court's ruling, the laws now have broadened to include more individuals, entities, and levels of neglect to support victims of child abuse. The results of the appeal directly affect education today because the decision changed the meaning of the word person in CSSA, opening schools, religious entities, and other types of corporations to lawsuits of liability. The court's decision also strengthened the Charitable Immunity Act by recognizing the difference between the law's protection from negligent torts versus instances of willful, wanton, and grossly negligent conduct. This means Cases of child sexual abuse could not be dismissed based solely on the fact that the entity is a charitable organization or a nonprofit organization like a school. So schools are definitely can definitely be liable for these different kinds of cases and instances, especially when it comes to child sexual abuse. And yeah, thank you for listening.